Good morning. Are you Summer Young?
Yes.
And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Young, in cause number 24 DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the second-degree felony offense of assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
Sure.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
Sure.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
Sure.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
Sure.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
None.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, you know? So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
For 90-day term.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff. And Mr. Schenkel, we've gone through this before, but I'm going to go through and make sure we're all on the same page again. And in that case, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And that's from October 15th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, October 16th of 2016. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a first-degree felony with a minimum punishment of 5 years up to 99 years or life in prison. Do you understand?
Yeah.
And I have a plea bargain rejection that you've signed now with Mr. LeBlanc that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 6-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure y'all have gone over everything. You understand and you want to go forward with trial.
Yes, ma'am.
All right, well then we will get your case moved to the trial docket. Mr. LeBlanc will begin preparation.
All right. Hey, thank you, ma'am.
Yes, sir.
You have a good day.
Thank you. Okay, we're back on the record. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, but there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason, would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before. Ask you to keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations was.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving and then causing the vehicle to crash.
We naturally kind of disagree with her version of the facts.
Can you hear me, Mr. Becker?
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McWade were in a relationship, and this was a fight that escalated. Change since the last time is he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron Electrical. He's a electrician and would go there and work and live at home with his parents. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job, but at this point, we just need to get the case set for whatever it's gonna get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for trial.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay, all right, then, well, I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion.
Okay,
Because
thank
I
you.
would consider that new, obviously, if he has to sit and wait for another trial docket. Okay,
Thank you.
all right, thank you. All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. And so we're asking for.
And Judge, may I just put my spin on that?
Please.
I would-
Because, and here's
I would
my
not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these elevated first degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're gonna do.
doable.
You've been on since last May, so we're 14 months into your representation. Last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not, and then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This
for
will
that.
be the last one.
Okay.
Okay, all right, you go back with the bailiff.
And that should also dispose of the co-defendant before you vote.
Good morning. Are you Jadarius Simmons? And this is 26 DCCR 0661. Mr. Simmons is charged with unlawful possession of a firearm by felon. And what is the announcement?
We're asking for a 30-day reset. We're at the end of the road.
You're what? I'm sorry.
We're at the end of the road here. We're on the same page. I think we just need to flesh out a few things.
I inherited this case from Mr. Coleman. I have tendered an alternative offer based on my read of it. I'd like maybe later DAs to look at that and see if they agree, just because of the variance between it. I don't know that he's been in custody that long. It would be a jail time offer, and so I don't know that that's an issue, but we could probably have it resolved by.
Yeah, it's fairly new case and you were just,
Yes.
filed your representation just.
This hearing shows just how much can depend on what a defendant does after receiving a second chance. The judge chose to continue probation, but the conditions and the warning were clear. From here, the outcome will depend on whether the defendant follows those conditions and stays out of further trouble. What do you think? Did the judge make the right call by giving her another chance?